Well, welcome back. Listen, we're in the defense closings here. You guys got it down. You know where they're going with this case. The Law and Crime Network has done the gavel to gavel, and we're at the end of the road here. And this is going to be a really compelling case. I love talking about it. Go to the chat room. Go online if you can, because now's the time to ask legal questions. I see there's a lot of debate going on in the chat room right now. I'm lucky today because we have some great guests. One of them is Joseph Scott Morgan from Alabama, and you are a professor at Jacksonville State University in forensics, and you're a forensic death investigator. Welcome to the show, Joseph.
Hey, good to be here with you, Bob.
So listen, I mean, we were right at the point of the defense closing. That's why we brought you in to explain a little bit of the forensics of this case. And you hear the defense lawyer doing the theme that any defense lawyer representing a cop is going to do. It's at the time that what he was perceiving, not what anybody else was perceiving, and whether it was reasonable. But Joseph, how did the forensics help or hurt the defendant in this case?
Well, you know, Bob, it's hard. It's hard to go back, even with forensics, and kind of talk about the dynamics of that evening. We can attempt to, through recreation, the attorney alluded to the fact that there was a very expensive recreation that was conducted. It all depends on how that's going to play with the jury. But just from a basic science standpoint, we begin to talk about relationships, physical relationships between the person that's discharging the weapon and where they were relative to their position and this vehicle. And this is key because, you know, this all goes into perception. You know, in the dark, could he have perceived himself to have been in danger? Well, maybe there's a factor of disorientation here. We don't really know. But they're trying to go back and paint a picture of a very non-static environment, and then they go back and try to capture it with the science or the diagrams that we generate, you know, at the lab and all these other places to try to demonstrate this to everybody in the court.
Yeah, Joseph, that's an excellent explanation. I think that sometimes, though, with forensics in courts, it could be very benign when you're dealing with a very active situation like this. You were at the Law and Crime Network, Roy Oliver trial. We're going to go to a break, and on the other end, come back with more crime. Wow, that was the defense closing statement, one of the defense lawyers out of two that got up and spoke. This is the Roy Oliver case, 37-year-old police officer on trial for his life, being charged with murdering that 15-year-old passenger in the vehicle. And I'm with Joseph Morgan, who is a forensic expert. And I know, Joseph, that you also worked for the ME in Atlanta and the coroner's office in New Orleans. This gets to my point what the defense is doing here. It only takes one juror that sits there and says, you could put on all the scientific experts, forensic experts in the world, but this was a rapidly unfolding situation. Listen to what the defense lawyer did. Look, whether you like this case or not, he did a good job. He brings out that Gross says he definitely came at me, which is why I punched the window. There's shots being fired. There's people running by. Gross also says he went by me very fast. I think these are very compelling arguments that are, with all due respect to the forensic experts, are a little more powerful than the actual forensic testimony. What are your thoughts?
Yeah, absolutely. If you reflect back to what Dr. Hayden said, who's the former FBI agent and now use of force expert, he was talking about, Bob, that you know, excessive force was used in this case. Maybe. I'm not really sure. I submit to you that Dr. Hayden, as esteemed as he is, was not there that night. And it all goes to perception, doesn't it? And we can stack a multiplicity of things relative to scientific findings and all of the little nuances that are involved in this. But at the end of the day, the defense attorney made a very compelling argument in this. You have to find this fellow guilty.
Right.
Guilty. Beyond a reasonable doubt. I think that this, you know, just based simply on that comment, this is going to be very, very difficult.
Yeah, Joseph, I agree. This is a fascinating case. I cannot wait to continue to come back and discuss it with you. This is the Law and Crime Network, a Dan Abrams production. You don't get any better than this kind of trial and an expert like Joseph. We have to take a quick break. On the other end, we'll come back with more Law and Crime. Well, welcome back to the Law and Crime Network. That was lawyer number 3, the trinity of lawyers that gave a defense closing. I'm with Joseph Morgan. I'm going to run right to it, Joseph. I know it's a little bit outside your field, but you've testified in court before. Have you ever seen a scenario where 3 defense lawyers get to give a closing in a case? I never have.
No, the last gentleman that spoke, it was reminiscent of some kind of a sentencing hearing where you're kind of speak to the character of the individual. It kind of struck me as bizarre. Like you said, I am not a true student of jurisprudence, but it does strike me as a bit odd.
I'll tell you, if I were a prosecutor prosecuting this case, I would be highly disturbed that they get 3 bites at the apple with respect to this. Nevertheless, they do get rebuttal, and that's where we are. Let's get to it. Welcome back, Law and Crime Network. Boy, I'll tell you, there's some really hot summations going on, a little bit of weirdness here. Joseph, you're still with us, forensic expert. Before we get into a little bit of the forensics here, I mean, wow, this prosecutor in his rebuttal did some things that you wouldn't be able to get away with, at least in New Jersey or New York. Personal attacks, directing questions directly at the defendant, testifying about things that or saying things that were not testified to in the record. I mean, he had some great one-liners and some great pot shots, but trials are supposed to be about evidence, not about character assassination. But I guess in Texas, this kind of thing is allowed to happen because there were no objections and the judge didn't rein it in. What are your thoughts?
I felt like I was at a revival meeting, Bob. He was very, very passionate about, or at least he displays that he's very passionate about his feelings toward this officer. And I was curious that he brought these other issues up. Apparently, the defense left the door open for this, and I'm going to be interested to see as to how this impacts the jury when they make that long walk, and it is a long walk into that jury room. They're going to be sequestered, and they're going to have all of this stuff floating around the air. All these things they're going to have to kind of synthesize down to the ultimate truth here. Is this fellow guilty? Is he guilty of murder? And that's going to be key. Well,
listen, Joseph, the chat room on the Law and Crime Network is on fire right now. There's a lot of controversy going on about some of these statements that were made. Hey, listen, we're not judging the case. I, as a prosecutor, a homicide prosecutor who's prosecuted cops in my career, I want a clean conviction. I don't want reversals like we have in the Hubers case. I want to win this fair and square. Now, again, state rules are different about what you can get in or not. But so it's clear because it's been asked in the chat room. There's also another area that he went into. I mean, it's powerful. And to answer your question, Joseph, the victim impact statements that he was making by pointing to that he won't be a grandfather and how much blood do you want, Oliver? I mean, these things are very powerful, but they're really not based upon the evidence in the case. And again, Texas allows it. To answer your rhetorical question, I think it's going to have a significant impact on this jury. And you would agree with that, right?
Yeah, I would, and I think that it would. Look, Bob. At the end of the day, I like a good play on emotions as much as anybody else. I guess I like to pay my ticket and go to theater for that. But I'm a science guy when it comes down to it. Tell me the facts. Let me know what's going on. Let me see the diagrams. Let me see positionality relative to firing. Let me see the dynamics of the event played out as to what they collected at the scene. The distribution of spent casings, the movement of all of the principals in this particular environment, because I want to judge this thing coldly, you add this other element into it, and for a science guy, it kind of leaves me kind of dangling in the wind.
Yeah, and it may with some jurors too, especially sometimes you want to pick a real science-oriented person, a precise person, accountants, people of that nature, because they deal with those exactitudes. They don't like gray areas, and they don't like a lot of fancy footwork like this. Hey, Joseph, great stuff. We got to take a break. I love this case. Law and Crime Network. We're going to come back on the other end of the break with more Law and Crime. Okay, we're back. We're being asked in the chat room, what are the 6 pictures of the guys? The thing I got underneath there is 6 guys in jeans with no shirt on and ripped abs. I guess you all don't have that there. The answer is none of those guys are me, obviously. But I do have Joseph with us. Joseph, that last top crime story there with the Prince case, let's do a little civil law here. I think this is going to be a little bit of a difficult case. I get it. Doctors prescribing medications are what they are. But Prince was using illegal drugs that the doctor did not know about. And in civil law, there's a thing called comparative negligence. That is, if you were a person that contributed to your problem, you could pretty much get 0 if it's over 50%. What do you think about this suit?
Yeah, I guess that it all comes down to the fact that, well, at least in my estimation, we're creatures of free will, are we not? We kind of make these decisions. I guess it could be argued that that perhaps the prescribing physician started him on this road, where he developed a dependency. I'm sure that this will probably come into play. And then he just had to, at the end of the day, kind of feed the beast because he wasn't receiving ample amount of fentanyl, which is what actually led to his death. He had severe, from what we understand, joint pain. If you danced around in those boots that he danced around in for so long, I could see how you would have bad hips and bad back and all this sort of thing. My wife and I were huge Prince fans, believe it or not, saw him in concert many times, and we were just totally amazed that he could do all these things, particularly at his age. And, at the end of the day, he wound up paying a price for it. Yeah,
if I read this story correctly, if I get it, he thought that the illegal drug he was getting was Vicodin, but in fact it was this fentanyl. The object of the suit is that weeks before he had an episode where he was on a plane and he overdosed. They had to make an emergency landing and he had to be revived in a hospital. And the law is, Joseph, that it's not the best medical care. It's not even good medical care. For a medical malpractice case, it has to breach the lowest level of acceptable medical care. And I think that this puts an awful burden on a doctor when, especially your client or your patient, is improperly ingesting drugs that they think are something, but are in fact laced with something else.
We've, having worked at the medical examiner in the coroner's office for, my entire working career in the field, we dealt a lot with deaths related to medical intervention. We always found it curious talking about this issue. If you or I go out and commit some type of negligent death, we could be charged with things like negligent homicide. It's interesting, physicians get engaged in stuff like this, and they'll refer to it as a medical misadventure, and I've always found that rather curious oddity along the way. So, I think that they're going to have a tremendous burden upon them to try to prove this, and it probably is. At the end of the day, you're talking about people's lives. It's a tremendous burden to put on the physician.
Right. So listen, we have to switch gears here. Roy Oliver case, we did a great summations here, and we were talking about this before. Something that I found very fascinating is that the defense was successful in precluding a previous incident of violent behavior by the officer, but the defense then brought it out through the police officer on the stand, and the prosecutor put a stake through his heart with that in the summation. Let's go back to a little bit more of the prosecutor's closing statement, and we'll talk on the other end. Thank you. That was not the prosecutor. That is for sure. That was Shayna Hubers, who's on trial for her life on her retrial on a murder case where she actually took the stand this time, and it was a doozy. Nevertheless, we are in the Roy Oliver case. We are flowing in this Law and Crime Network. We got a lot of activity going on, and while the producers are working, putting up the next clip for me, gives me more opportunity, Joseph, to talk to you, Joseph Morgan, forensic expert, about the statements that were made by the prosecution in summation. The more powerful one was him hammering this previous incident where he pulled the gun out with these 2 women. And because the defense was successful in eliminating that, and I believe rightfully so, it's what we call bad character evidence, other act evidence. And while it may be relevant to his demeanor as a person, it's just a court of law. And the rules are that you should be directed towards that specific crime, not a bunch of extraneous character assassination. But the defense brought it out through the police officer when he took the stand. What do you make of this?
Oh, my God. Yeah, the statement. I think the thing that really kind of grabbed me by the throat in this whole thing was the statement that the prosecution alluded to, where he said, and I'm paraphrasing here, I'm really good at one thing, and that's killing. And wow, what an impactful comment to make just before, and I mean just before this jury is about to exit this jury box and walk back into that room. I can only imagine, almost like the tones of a tuning fork, this thing is resonating in their ears, going back there, and it almost diminishes our trifecta of defense attorneys that were trying to make closings prior to that.
Yeah, listen, no, Nellie, I don't need Xanax. I love when something like this happens. It's like a courtroom. Things happen. I got people screaming in my ear, things going on. It's all good here at the Law and Crime Network. Joseph, I want to get back to one point that you just raised that I think is important. Since we're having some problems in the back room, which is great because I love talking about this. I love you guys in the chat room. Let's go back to what you just said. It's about what we call character evidence, not character assassination. It is not to be a trial about that, but in Texas, I guess you can get away with this. But bringing up Facebook posts and things that he had said, while that is not really relevant to this case, yeah, it kind of goes to his state of mind. But these evidence rules are very precise in most places. But I can't help but think, Joseph, that they're allowing it because there wasn't an objection to it. It is going to have a tremendous impact on the jurors in terms of sympathy, bias, and prejudice in my mind. Hey, I don't care if you're on one side or the other side. The fact is it's damning evidence. I think we're going to throw to a clip right now, Joseph, and we'll talk to you on the other end. Okay, let's do it. This is the Roy Oliver case. Diana, 421, this is for you. Richard, this case here that we're dealing with is forensic oriented. Joseph, I'm sorry, I'm losing it here. So do you think that in 10 seconds or less, the forensics are going to be more important than these powerful summations?
No.
Okay.
No, not as long as they continue on like some kind of camp meeting revival. No, it won't be.
Yeah. Hey, listen, you're getting a lot of play in that chat room. Nellie wants to read your book and love to sit in your class. We're going to have to go to a break, and on the other end, we're going to come back. It's one heck of a day, folks. Law and Crime Network. That was one of three defense lawyers who closed in this case. I am still with Joseph Scott Morgan, who is a professor at Jacksonville State University, has a tremendous forensic investigation background. And Joseph, the chatters love you. They apparently know you from somewhere. They're very positive about your experience. And I want to ask you, as a science guy, we were talking a little bit about this defense closing, talking about split-second decisions, gunshots. You put a uniform on, essentially, get into the car and go there. How the other officer was in danger, had to break the window, so therefore he must have been within 20 inches of the vehicle. Things are unfolding quickly. Oliver felt that vehicle was the danger vehicle because his partner, Gross, is telling that vehicle to stop, and they're not stopping. You're a science guy. If you're sitting on that jury, are you going to go more back towards your science piece, or are these arguments by the defense resonating with a guy that has your kind of academic background?
Well, yeah, I would probably, my nature is to list back to the science. I want to try to understand, again, I go back to the word dynamic. I've worked, over the course of my career, I've worked several police-related shootings. I've had police officers that are dear friends of mine that are no longer with us because they were killed in the line of duty. I've had to work their cases, and it is dynamic. And, it's easy to get impassioned about these things, but at the end of the day, you have to step back and put that passion aside and look at it coldly. And that's hard. That's very difficult for a lot of people out there to do, I think. And it's been hard for me over the years to have to do. So for me, I would, the why is not as important to me in forensics as the how. Mm-hmm. That's always kind of kept me going. I want to know how this happened. And for me, and that's my role, I want to tell people how this happened as in terms of science, and then let them make the decision. The science part is kind of the easy part, isn't it, Bob? Moving forward, because now they have to think about reaction, response. They have to, and the biggest key here is perception. And there's no way to kind of go back and revisit that and kind of infuse that into the court. What was your perception at that time? Mm-hmm. Well, perception is relative to the position that you're in. It's dark. You've heard shots fired. You've got literally a chaotic situation where it was kind of calm before. Right. And so it's very interesting.
Yeah, Joseph, if I were the defense attorney in this case, I would have picked everyone like you, everyone with an engineering background and accounting background, because they want exactitude. They don't want platitudes and fancy statements and flourishing language. We'll be back on the other end of the break. Welcome back to the Law and Crime Network. We're covering the Roy Oliver case. We like to have a lot of fun here at this network. Gavel to gavel coverage. Dan Abrams production. Joseph Morgan, we're back here with this case, and we were talking about a fascinating aspect of it. That is the defendant taking the witness stand, and there is nothing more powerful for a prosecutor than to score points from the defendant himself, because juries love to convict out of the words of the mouth of the defendant. And this police officer should be trained in testifying. What are your thoughts?
Yeah, you're absolutely right. And again, it comes from always waiting in the all those days and hours and days that you spend waiting out in the area there outside the courtroom to go in and testify, because you testify about everything as a police officer. It's for defense, I can only imagine it can kind of be, in this particular case, kind of be cringeworthy. I have visions of them digging their fingernails into the wooden table there as he's going up on the stand, because you don't know what is going to be said. You don't know what's going to trigger him. And let's keep in mind, if the prosecution is so probative with this fellow that they think that they can press buttons with him, they try to portray him as a rage-filled, angry man. I think that was what the prosecution said in closing. Then they're going to try to press his buttons in this, and that's probably the tack that they would take.
You know, one of the things that you do as a technique, as a trial attorney, as a prosecutor, is even if this guy's really good and he's kind of impenetrable on the facts, is you just bring your case back out through that witness. He could say no a million times, but you could do it this way. Isn't it a fact that this? It is a fact that that. Isn't it a fact he was unarmed? Isn't it a fact that he wasn't driving the vehicle? Isn't it a fact? And you just could bring your whole case back out through that witness, through that witness. So I think it's a really dangerous move for the defense to put him on, and we know it definitely exploded. We got to go to a break, Joseph, but on the other end, we're going to come back with more. Okay, welcome back. That's the defendant, Roy Oliver. He is on trial for his life, and he is on the witness stand. He has a right not to be on the witness stand. He has a right to remain silent. The defense doesn't have to do anything in the case. They don't have to do an opening. They don't have to do a closing. They don't have to cross-examine a witness. That's the instruction the judge will give to the jury. Nevertheless, they've done it all, including putting him on the stand. And as we will talk later, Joseph, there could have been a big faux pas that occurred. We're asking the producers to see if we can get that clip. Maybe we'll talk about it on the other end. But right now, he's going through the details of how the event unfolded. It was calm, it was peaceful. They were doing a police interdiction, and the gunshots are fired. And the lawyer is trying to put him in the jurors in a space where, kind of like, what would you be doing if this happened? Everyone else is running away, and these cops have to run towards it. What do you think?
Yeah, I think that one of the things that can be rather dry but yet compelling in a case like this, I'm wondering at some point in time, have they had an individual other than the use of force person that was up on the stand that deals in departmental SOP, which is a standard operating procedure? What is expected out of these individuals at that particular time? Again, I'm putting my science hat back on and going here, what are the bare bones facts here? What does it say that you must do in order to correct a situation or interdict a situation, and using that as the template to work from? Did he meet that standard? Did he meet that standard going forward? And does he, at a higher standard, did he meet the standard of law? And I think that that's what they're going to have to prove here. And again, this is spiced up by this impassioned plea by the
Let's listen to some more of his testimony, though. Welcome back. Well, Joseph, we're listening to this testimony of the officer. Do you think he's making a good impression on the jury with regard to the frenetic activity that's going on there?
Yeah, he's got a very kind of a calm affect about him. He's not overly demonstrative. He's just kind of placing his hands in front of him and talking very calmly about what the circumstances were as he perceived them that particular night. And again, this goes back to this dynamicism that's going on at this scene. And if you watch that body cam video, Bob, it's very frenetic, isn't it? And prior to it, when they're walking through the house, you can hear the report of those gunshots outside the house. So it kind of gives this, you're thinking about this guy is caught up in the storm of this thing, and now he's going to exit out of the home. so many officers have been accused in recent memory of not reacting quick enough to put an end to violent situations. Because when I first heard that he went to his vehicle and retrieved the rifle, I'm thinking, wow, why didn't he just automatically go to his firearm, his sidearm, this pistol, as opposed to going to the car and retrieving the rifle? Well, it sounds as though that he was trying to be proactive.
Yeah, let me just jump in there. I think that's a really important point because there had been shootings there. I think previous that night there had been a murder a couple of weeks prior to that in that location. Gunshots are going off. People are running. So if I were the defense lawyer in this case, I would be making the argument that he felt he needed more firepower. He's calling in an active shooter scenario. He's running up to a car where the other officer has his gun out. He's giving commands to stop. That officer breaks a window, which could have sounded like a gunshot as well. So there's a lot of activity that's going on there. That's the argument. But look, it's like you said earlier. It's about the body cam. Let's take a real deep dive into that body cam video. All right, listen, I've got Joseph Scott Morgan with us, forensic expert. Now, going back to the point we were saying just before that body cam video, I think tactically, Joseph, and I know that you know this world, that when he separated himself from his partner, there was a big mistake made there because now he's running back to the scene with a more powerful firearm. He hears his partner's voice ratcheted up. He knows he's directing his attention to that car. You can hear him yelling, "Stop that, car! Stop that car!" Expletive, expletive. Things are really in the heat there, and that car is moving away. It was just a constellation of horrible things that occurred at one time. Thoughts?
Yeah, I mean, I guess I could Monday morning quarterback their activities. But again, I'm curious as to, relative to departmental policy, why would he have gone back and retrieved this weapon from his vehicle, which arguably is a much more powerful weapon than his handgun? But it would seem as though that the handgun would have presented with sufficient force to negate anything that was going on. And I understand you want to show up with the most firepower possible. But this is not, we're not in Afghanistan here. We're in a neighborhood with a bunch of kids, and it's a very dangerous mix. And you're right, the separation that has taken place. If you're watching your partner's back, why have you taken time to go over to the patrol car, grab the weapon, and then reinitiate at that point in time because you've lost perspective at that time? That's the only thing I can think of.
Yeah, and if I were the prosecutor, I would make a big point that the defense is sitting there saying that it's all about protecting the partner, making sure the partner goes home. Well, I was an EMT, and we were in some scrappy scenarios sometimes. We never left our partners, period, end of story. He did to get more firepower? Makes you think. Hey, listen, we got to take a break, Joseph. On the other end, we'll come back with more Law and Crime. I have asked the producers at least 3 or 4 occasions, like, is this possible that the defense was successful at having this excluded? The defendant gets on the stand and is introducing bad character testimony about himself, which the prosecutor used like a sword and stabbed them over and over again in the closing. And it also caused them to be able to put 2 rebuttal witnesses on, the 2 women that were the subject of the road rage. You got 10 seconds. What do you think of this, Joseph?
I don't know. It's almost like they wanted him to put a noose around his neck with this because they're introducing this really, really terrible evidence here.
I can only think that right now they've opened a post-conviction relief or some appellate issue where this cop, if he gets convicted, can say, I was malserved by my lawyers. We're going to a break. We'll be back. Welcome back. Gizmo's mom in the chat room. I agree it could potentially cause a new trial by having him testify to something that they had excluded as a prosecutor. I would have gotten up and said, whoa, Judge, what's happening here to protect the record? Hey, we were with Joseph Morgan all day today, forensic expert, investigative expert. He'll be back with me on Wednesday between 12 and 3, but unfortunately he's got to go. Joseph, thanks so much for the excellent commentary.
The family out there watching.
Okay, great. All right, Joseph, we'll see you Wednesday. So, guys, listen, you know I love it. It's Top Crimes Lunch, and we're going to get to that. And on the other end, we're going to come back. This has been one heck of a day, some great lawyering. And thank you, Joseph. Law and Crime Network, Dan Abrams Production.